I'm Larry Swikart, co-author of A Patriot's History of the United States and founder of Wild World of History, www.wildworldofhistory.com. I'm here for this session to talk with you about one of the most important elements of the U.S. Constitution, the Bill of Rights. So as we've done in previous episodes, I'm going to read the Bill of Rights and comment on the various sections one by one. On September 25th, 1789, the U.S. Congress proposed 12 amendments to the U.S. Constitution. 10 of these were ratified by 3/4 of the states by December 1791, making them a part of the Constitution. We call these the Bill of Rights, but as the great Rush Limbaugh once said, they really are ill-named. They should be called the Bill of Limitations, because they are limitations on what government can do to us, not limitations on our behavior. The conventions of a number of the states, having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. Resolved, by the Senate and House of Representatives of the United States of America in Congress assembled, 2/3 of both houses concurring, that the following articles be proposed to the legislatures of the several states as amendments to the Constitution of the United States, all or any of which articles, when ratified by 3/4 of the state legislatures, to be valid to all intents and purposes as part of said Constitution, viz. Articles in addition to an amendment of the Constitution of the United States of America proposed by Congress and ratified by the legislatures of several states pursuant to the 5th article of the original Constitution. Article 1. I should mention I am now listing these as they now appear in the Bill of Rights. As we sit, 2 of the articles were not adopted, right? So I'm starting to read to you from the original additions, the original amendments, and we're going to see that 2 of these are going to get kicked out, and then I'll renumber them at that time. So Article 1. After the first enumeration required by the first article of the Constitution, there shall be 1 representative for every 30,000 until the number shall amount to 100, after which the proportion shall be so regulated by Congress that there shall be not less than 100 representatives, nor less than 1 representative for every 40,000 persons, until the number of representatives shall amount to 200, after which the proportion shall be so regulated by Congress that there shall not be less than 200 representatives, nor more than 1 representative for every 50,000 persons. This was never ratified, so we don't need to spend our time discussing it. Original Article 2. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. Again, this one was not ratified, but was later ratified in 1993 as the 27th Amendment. So their Article 3, original Article 3, now becomes our new modern Article 1, the one you will see in the Bill of Rights. Article 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. We could spend our whole session on this article. Indeed, we could spend our whole session just on the first phrase of this article. It is a constant, unresolved question, usually today contained wrongly in Thomas Jefferson's 1802 private letter to the Danbury Baptists, in which he used the phrase, a wall of separation between church and state. Remember, Jefferson was not there at the Constitutional Convention. Jefferson did not speak for the authors of the Constitution. Second, he wrote in a private, not official capacity, offering his opinion. It's almost unfathomable that this has been taken to the lengths it has been taken, because it is written by somebody that had nothing whatsoever to do with the Constitution, that expressed no view of those who were at the Constitutional Convention. Third, each of the colonies was distinctly formed along lines of particular Christian denominations. Rhode Island for Baptists, Massachusetts for Puritans, South Carolina for Anglicans and Presbyterians, Pennsylvania for Mennonites, Virginia for Anglicans, Maryland for Catholics, and so on. It was widely assumed that each state had its own laws, quote, respecting the establishment of religion. Massachusetts paid ministers until well after 1800. Consider just these statistics. 5 states, not colonies, 5 states granted privileges to specified religions that lasted well past the U.S. Constitutional Convention. 7 states guaranteed the freedom to practice your religion. Delaware specified an oath of office, quote, that I do profess faith in God the Father and in Jesus Christ, his only Son, and in the Holy Ghost, one God. North Carolina's 1776 Constitution says, quote, no person shall deny the being of God or the truth of the Protestant religion. 5 states required public office holders to be Christians. Seems today we are leaning in the other direction, requiring them not to be Christians. 7 states required that public office holders state that they believe in God, and most important, no state mentioned any religion except Christianity. Moreover, the notion that the founders were deists is absolute nonsense. George Washington's handwritten manuscript in 1752 includes one of his prayers, quote, O most glorious God, in Jesus Christ, I acknowledge and confess my guilt in the weak and imperfect performance of duties of this day. Peter Lilback, the best scholar on Washington's faith, has a massive book called George Washington's Sacred Fire, and he proves Washington's Christianity beyond doubt. Benjamin Franklin repeatedly wrote and said things that indicated that while his belief in Jesus was flimsy to non-existent, he definitely believed in an interventionist God, not the watcher of the deist worldview. In short, the men who wrote the Constitution were Christians and never believed that the government would in any way prohibit religious expression in public places, but rather only the federal government could not override state laws regarding religion. The notion that the Establishment Clause applied to the states was introduced in Everson v. Board of Education in 1947. And from then on, states lost the authority to determine their own religious cultures. In 1962, Engel v. Vitale, prayer in public schools was stricken down as a violation of the separation of church and state. As far as, quote, abridging the freedom of speech, this very clearly was intended to be political speech. Now, it's interesting, whenever you bring up freedom of speech, somebody immediately says, yeah, but you can't yell fire in a crowded theater. Well, you most certainly can if there's a fire. In fact, you would be criminally negligent if you didn't yell fire in a crowded theater and there was a fire and you didn't alert anyone. Currently, with our social media platforms taking the place of government censors, a serious new question arises of whether or not Facebook, Google, Twitter, and others are publishers in which they have a right to control content and can therefore be regulated differently, or if they are platforms in which they are under previous American broadcasting laws that would subject them to fairness doctrines that would keep them from banning any speech except that prohibited by the criminal code. This issue has not been resolved at all. Those who oppose government getting involved in such platforms cite the threat to freedom of speech, but those who see the big tech platforms as in bed with the government argue that they are performing a censorship function for one party in power. We are still some ways from getting this resolved. Likewise, the freedom to assemble under COVID restrictions has been attacked, and again, so far there's been no clear guidance from the courts. Churches in California have been victorious under the Freedom of Religion Clause, but not under the Freedom of Assembly Clause. But we have no important test cases as to whether or not lockdowns are in fact legal if they violate freedom of expression or freedom of assembly. Article 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. For decades, gun control advocates have used the phrase a well-regulated militia to try to limit firearms ownership by individuals. But as scholar Stephen Halbrook wrote in his book, That Every Man Be Armed, in fact, the history of American individual arms ownership goes all the way back to England, even to 1132, with the Assize of Arms, in which the British government, the king, required that every Englishman be armed. This will knock your socks off. And required that mayors go door to door and saying, do you have arms, bows and arrows, spears? No? Here's some. We're going to give them to you. So under that aegis today, instead of gun buybacks, we would have situations where the mayor of Chicago would go around and make sure everybody had a gun, right? Not happening, but you know what I'm saying. The practice in early America was for people to protect themselves. Why? They could not rely on England for protection. Even if the English agreed to send troops in a specific situation, they would arrive months too late to be of any value. So a militia was a component of every state and local government. Well regulated meant that they were under control of the people via their governor or legislature, and that they trained and practiced regularly. Gun control in those days was the ability to control your gun. It is critical to understand they were not the standing professional army. The militia was not the standing professional army. Those were the redcoats, right? And by the way, Paul Revere never rode through the countryside going, the British are coming, the British are coming. Why? Because Paul Revere was British. He would have said, the redcoats are coming, the redcoats are coming, meaning the standing professional army is on its way. The militias were viewed as a counterbalance to the king's soldiers. After the Revolution, the militia was viewed as a check on tyrannical government. The phrase, shall not be infringed, is not only an absolute statement, i.e., there's no conditions on that, folks, not by anyone, even a state or local government, but it's also an individual right. And this has been upheld in two fairly recent U.S. Supreme Court cases, most recently Heller, which said that the right mentioned in the Second Amendment is an individual right and guarantees the individual the right to use firearms for traditionally lawful purposes, including self-defense. Article 3, no soldier in time of peace shall be quartered in any house without the consent of the owner, nor in time of war, but in a matter to be prescribed by law. What's this all about? This goes back to the Quartering Act right before the the American Revolution, where the British government put squads of soldiers inside people's house and made them pay for the upkeep of these soldiers, for their food and their lodging, right? Imagine if the local basketball team came to your house and you had to feed all of these guys. So this is specifically a response to the Quartering Act. Article 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by the oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This article obviously prohibits illegal or unwarranted search and seizure. More recently, however, snooping and data collection by the National Security Agency has been revealed to have collected data on millions of Americans without their consent and without a warrant and without their knowledge. So far, no action has been taken against either the agency or the individuals involved. But this article stipulates that when you get a warrant, it cannot be for just anything. It must be specific to the things you are looking for. This, too, has been widely abused by police, who use a warrant as an excuse to, quote, look around the house for other possibly criminal evidence they could use to get yet another warrant. Article 5, the famous Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in the actual service at the time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Pretty long, but what this means is, first, no one can be arrested without an indictment from a grand jury except in wartime. And no one can be put on trial twice for the same crime. This is famous double jeopardy. No one can be made to testify against himself, a clear prohibition of torture to get people to talk. It's the basis for many of the mobsters' testimony before Congress where they invoke their Fifth Amendment rights, but they are lawful in doing so. Recently, we have seen one political party use congressional testimony to try and set up perjury traps for special counsels to use. If someone testifies before Congress in the slightest way different than what they told a special counsel, they could be charged with perjury. And this is almost to the point of saying, I was happy when they came in to one group, and then I was glad when they came in to the other group. It's getting that fine. In such cases, citing the Fifth Amendment is probably the smart move. Finally, the government cannot take your property for public use, say building a freeway, without compensating you for it. Often, however, when the government under eminent domain does seize land, it seldom pays the true value of what has been taken. Article 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have an assistance of counsel for his defense. Now, this article promises that people cannot be held in jail forever without trying them. The trial must not only be speedy, but public, no star chambers as we had in England, where people were whisked off to secret trials, and held in front of a jury of one's peers in the district in which it was alleged to have been committed. Now, this has come under a lot of scrutiny, especially on college campuses, because many colleges have rules that under sexual harassment or sexual abuse claims, the defendant, usually a male, cannot confront his accuser, which is a clear violation of the Sixth Amendment. And so this is coming up. Just the other day, there was a court ruling on this regarding one of the colleges. So this is a problem. An impartial jury. What's an impartial jury? Is a jury of your peers a jury of people who reside in the same district as you? Or is it a jury of people who are in the same socioeconomic class as you? Or your same race? We saw, for example, in the O.J. Simpson trial, a case of jury nullification, basically, by returning a not guilty verdict because of largely race. So what constitutes a jury of your peers? This was in response to the British habit of shipping the accused back to England, where they did not get fair trials. Recently, the concept of an impartial jury by your peers has come under scrutiny, as so many people are exempted from jury duty. The ultra-rich, for example, almost never serve on juries, citing financial hardship. Others are often dismissed by attorneys simply because they are likely to be predisposed to side with the opposition on a case. Many are kicked off juries just for their race or their class or the way they talk. Jury reform continues to be a nagging problem for American justice. Then there is the right to confront your accuser, which, as I mentioned, on many college campuses has been violated, almost always against males, by schools, quote, protecting the identity of female accusers. In some cases where DNA has become available, wrongly jailed men put away on the words of a woman he never saw in court, let alone cross-examine, has freed these men. In the age of the Me Too movement, no one knows where this ends, but confronting the accuser is a key element to the criminal justice system. Finally, the Fifth Amendment provides for every person to have a lawyer present with them, and if they cannot afford one, a public defender is provided. All in all, the Fourth, Fifth, and Sixth Amendments are amazing statements of human rights and the commitment of the United States to ensure justice for all. Article 7. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. Otherwise, it is in suits between people that do not involve criminal violations. It also goes to juries and courts who cannot overturn the jury's conclusions. Article 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This really is more in common with Articles 4, 5, and 6 than Article 7, and states that bail cannot be so high people can't meet it, and cruel or unusual punishments such as torture or being forced to listen to a Miley Cyrus album cannot be imposed upon the convicted. Seriously, it prohibits excessive force and punishment, especially in cases involving the death penalty. The founders kept in their mind the phrase drawing and quartering, which was still in use in England at the time of the Bill of Rights. The last instance of drawing and quartering in England was in 1803. This hideous punishment involved hanging someone until almost but not quite dead, live disemboweling them, and then tying each of their limbs to a different horse and pulling in separate directions at the same time, ripping off all four limbs before they were to be beheaded. You can see why the founders wanted to end this one. The excessive fines refers to seizure of private property during a drug raid or other case of civil forfeiture. Article 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This is very important. This is James Madison's attempt to ensure that the Bill of Rights was not seen as limiting the people only to these rights mentioned in the Bill of Rights, but also including what are today called unenumerated rights. Article 10. The powers not delegated to the United States by the Constitution, not prohibited to it by the states, are reserved to the states respectively or to the people in order to prevent the misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, as extending the ground of public confidence in government will best ensure the beneficent ends of this institution. In one of the most important articles of our Constitution, Article 10 states that any powers not delegated to the U.S. government in the Constitution or prohibited to it by the states are reserved entirely to the people. America is not a democracy. America is a republic. This comes from Latin res publica, rule by the people. There are many known anti-federalists who, as we saw in an earlier lesson, were really federalists before the nationalists pulled off a PR coup and renamed themselves federalists. But these anti-federalists still thought the federal government was too powerful under the Constitution. These included people such as George Mason of Virginia. But possibly one of the best critiques of the new Constitution came from Mercy Otis Warren, sister of Revolutionary notable James Otis. In 1788, Mercy Otis Warren wrote Observations on the New Constitution and on the Federal and State Conventions. She claimed there is, quote, no security in the proposed system for the rights of conscience or of the press, that there were no well-defined limits on the judiciary, where she was dead on, that there were no trial by jury in civil cases, that Congress could determine its own salaries, that there were no term limits, she said, no provision for a rotation, that the ratio of representatives to people, 1 to 30,000, was insufficient, that there was no Bill of Rights, and others. As we see, most, if not all, of Mercy Otis Warren's concerns were actually addressed in the Bill of Rights, or perhaps we should say in the Bill of Limitations. And that's the Bill of Rights. I am Larry Swikart, co-author of A Patriot's History of the United States, founder of Wild World of History at www.wildworldofhistory.com.